5 seconds to go. Start. The petitioner filed a suit for specific performance of an alleged agreement of sale dated 15th July 2003. The trial court dismissed the suit by judgment and decree dated 19th May 2008. The High Court dismissed the petitioner's appeal. Both the courts held that the petitioner had not approached the court with clean hands and that he had failed to prove any concluded contract for sale. High Court found that the defendants in the suit were also not above board in their conduct. It found that both sides were guilty of having lied on oath and deserved to be prosecuted. On the ground that courts were overburdened with litigation, the High Court decided that instead of directing prosecution, levy costs should be levied on both petitioner and respondents to be paid to the state which spends money on providing the judicial infrastructure. It then proceeded to impose exemplary costs of rupees 1 lakh on the petitioner and rupees 1 lakh on the respondents and directed that the costs should be deposited with the Delhi High Court Legal Services Committee. Feeling aggrieved by the dismissal of his appeal, the petitioner is before this court. On merits, we find that the concurrent findings of the trial court and the High Court do not warrant interference, and therefore this is not a fit case for grant of leave. The learned counsel for the petitioner submitted that levying costs of rupees 1 lakh against the petitioner was not warranted. He submitted that as the appeal before the High Court arose out of a civil suit, costs were governed by sections 35 and 35A of the Code of Civil Procedure and cannot exceed what is leviable under those provisions. Under section 35 of the code, award of costs is discretionary but subject to the conditions and limitations as may be prescribed and the provisions of any law for the time being in force. Under section 35A, compensatory costs for vexatious claims and defences may not exceed to rupees 3,000. Further, the primary object of levying costs under section 35 and 35A of the code is to recompense a litigant for the expense incurred by him in litigation to vindicate or defend his right. It is therefore payable by a losing litigant to his successful opponent when an appellant or a plaintiff has already paid the prescribed court fee in regard to the appeal or suit to the state at the time of institution. It is debatable whether any cost can be awarded to the state by way of penalty in a litigation between two private parties. One view has been that the provisions of sections 35 and 35A of the code do not in any way affect the wide discretion vested in by High Court in exercise of its inherent power to award costs in the interest of justice in appropriate civil cases. The more sound view, however, is that though award of costs is within the discretion of the court, it is subject to such conditions and limitations as may be prescribed and subject to the provisions of any law for the time being in force. Stop.